You think an LLC operating agreement is just another piece of paper? Think again. In this video, I'm going to give you 6 reasons why you need an LLC operating agreement and the risk you run if you do not have it. All right, let's get started. Okay, so here's the thing. People tell me all the time, oh, I don't need an LLC operating agreement. I was told that all I have to do is file my articles and I'm good to go because my state does not require that I have an operating agreement. That type of thinking is going to get you into trouble when you're trying to operate your business. And whenever I hear that, I just cringe because those individuals who operate that way have not yet been tested. Because the last thing you want to be is in a situation where you need it and you don't have it, because that's just going to turn around and come back to bite you. So here are my 6 reasons why you need an LLC operating agreement. Let's go over and I'll show you what I'm referring to. All right, so why do you want to have an LLC operating agreement? Well, see, state statutes cover a lot when it comes to an LLC. They have what are called default provisions. And what that means is that if you're in a situation with regarding your company and you don't have a provision that describes how this decision or how an outcome should be made or handled, then the state statute will control that. It's kind of like dying without a living trust or a will in place. The state law will determine who receives your assets when you pass away. Well, the same thing with an LLC. The state law will determine what a creditor has access to, what types of liabilities you personally have, if you haven't limited your liability in your operating agreement. So it's really important that we create operating agreements to make sure that we're protected and we know what type of protections we have or what type of authority we have to do certain things. Because if a lawsuit develops, I bet you this, that those creditors, those attorneys that are coming after you, they're going to be looking to pierce holes in your limited liability company, to state that you were doing things that were not allowed under state statute, that could have been allowed if you had them in an operating agreement. But you didn't know that because you never drafted one. That's why it's equally important is that you understand the operating agreements you're putting into effect and you're using someone who also understands what you need and you have that built into your agreement. Okay, so what are some of the reasons why you need an LLC operating agreement? Number 1 is going to be officer provisions. Okay, so what do I mean by that? So one of the things that comes up a lot when dealing with limited liability companies is who's going to make the decisions with respect to that LLC? Who's empowered to do this? Now, if you've set up an LLC, maybe it's manager managed, maybe it's member managed, whatever it is, maybe you got a holding company there. If you don't want third parties, tenants, customers, people that you're doing business with to know this is your company, then you don't ever want to have to sign on behalf of your company as a member or as a manager, because that just gives it away. So a better solution to avoid having someone know that this is your company is to claim that you're an officer. I'm a president, I'm a vice president, because that doesn't denote ownership like member manage or manager manage tends to denote when you're dealing with third parties. So how do you create officers in an LLC? Well, let's assume that I wanted to act as president for my limited liability company and I signed all these agreements as president. Here's what could happen. I default on one of those agreements. A third party that I entered into that contract with could come after me personally because they would say the LLC statute does not allow or does not provide for officers. So I was signing in a representative capacity that was not provided for under the statute. Therefore, potentially, I have personal liability now, because I was not acting in an authorized capacity. So how do you change that? You put together an operating agreement that states that the LLC can empower officers to make decisions on behalf of that company. So officer provisions I think are important. I use them a lot in my LLC operating agreements. My clients will use them when they're operating on behalf or representing their company, so people don't know that they're involved as an owner of that particular company. All right, that's number 1. Number 2, charging order protections. All right, this is important. Okay, so I have a video on the best state to form a limited liability company in. I'll put a link in the show notes to that video where I talk about charging order protections. But here it is in a nutshell. If you're sued individually The last thing you want is a creditor to be able to take your interest from you or petition the court to say, hey, I have some other remedy available. So what we want to do is when we draft an operating agreement, we want to specify in there that the creditor of a member of a limited liability company that we own, their exclusive remedy is a charging order, that no other remedy under that operating agreement shall be given to a creditor of a member. And that also goes with assignment. That is, we don't want to have a situation set up where the member can be forced to assign or transfer their interest to a third party. So we block that inside of our operating agreement by stating that the interests are not transferable to a third party. So those types of provisions many times are not covered under the state statute adequately, and they leave the door open. All right, the third thing that I'd put in there, why you need an operating agreement. When you sell assets. All right, so let's assume that I want to sell real estate that's held inside of my limited liability company. When you go to sell that property, the title company is going to ask you for a copy of your operating agreement to see that you have the authority on behalf of that LLC to sell it. They also want to see who the members are. Now, if you don't have an LLC set up or an operating agreement, then they don't know, and that's going to create problems and possibly delay the closing on the sale of a property. So if you're running a business or you're owning assets, it stands to reason you need an operating agreement to make sure that you can effectively run that activity through that LLC, and you're not telling them, hey, I rely upon state statute to determine how my LLC is operated. How do you think that sounds to a third party? Okay, number 4, if you want to make a Wyoming LLC the member, okay, so this is the holding company, holding LLC strategy. Okay, I have another video on holding limited liability companies. I'll put a link to that in the show notes as well. Check that out if you're not familiar with using a Wyoming LLC. But here's the thing. So you'll see that a lot of times I draw out structures that look like this, where you have an LLC, 1 or 2 LLCs, and they're assigned over to a Wyoming holding company. So you transfer your interest in this LLC to the Wyoming holding company. Now, in order to do that, you have to assign your interest in your limited liability company. So you have to have a procedure set up inside of your operating agreement on who is a permissible transferee. That is, who can you transfer that interest to, and what are the procedures you must follow. There was an interesting case about 1.5 years ago where an individual attempted to transfer his interest to another party to avoid a creditor. Problem was he didn't do it right, didn't follow the law, didn't know what the proper way to do it was, and so that transfer was held to be null and void, and so they were able to go after his interest and break his LLC and take his assets. You don't want that to happen to you. If you're setting up a Wyoming holding LLC down here for asset protection purposes, the last thing you want to be is in a situation where somebody sues you personally and they say, hey, this doesn't exist because these interests, I mean, it may exist, but this transfer here doesn't work because you didn't have a mechanism in place to make that transfer. You had no operating agreement describing how that transfer is going to take place. Therefore, it's null and void. So if you're going to set up a holding LLC, you want to make sure that you have an operating agreement describing how that's going to run. Okay, number 5, tax status. All right, this is a problem for individuals that are electing to treat their LLCs as partnerships or S corporations or C corporations or disregarded entities. Because what happens a lot of times is that we make a tax election. We set up an LLC, then we apply to get an EIN, and we tell the IRS, oh, our LLC is going to be treated as a disregarded entity for federal tax purposes. But we have 2 partners involved, husband and wife, and they live in a community property state, and we were told we could do that. But the default provision is that it's going to be a partnership, but we don't have the language inside of our operating agreement to hold that that LLC is going to be treated as a disregarded entity. Therefore, you can fall back into the default language, which the IRS would say it should have been a partnership, and that can impact us from a tax perspective. Similarly speaking, let's say you set up an LLC and you want it to be treated as an S corporation. You have 3 partners inside of that LLC. If you don't have an operating agreement that states that it's intended to be treated as an S corp and you have those S corporation tax provisions in there, then what can happen is, again, the IRS can come in and say, well, the default language is it's supposed to be a partnership. There's multiple members. We don't see the S corporation language in here. And now they disallow your S corporation tax status, treat you as a partnership, and hit you with penalties and interest on taxes you should have been paying. So that's really important. The 6th thing that I would put in here is death. Okay? Now there are many more. I'm just talking 6 that I think are really important. And what do I mean by that? What happens if you pass away and you don't have an operating agreement in effect? You've never drafted one. What happens to that membership interest? Who's going to take it? How is it going to pass on through your estate? What is going to show that you created an LLC and you were a member in that limited liability company? Because without that operating agreement, there's no proof that this is your LLC, that you set it up, and that you held this interest. And it can cause problems. Let's say if there was an estate dispute amongst your beneficiaries as to whether or not who was to have that business. Or maybe one child just steps in automatically and says, well, it was really mine. Dad gave it to me. Prove it. Prove he didn't. Prove he did. Those become the problems. So if you are thinking about estate planning as well, and you want to make sure that your LLC is held in your living trust, you got to have an operating agreement that issues out membership interests and then has, again, a procedure in order to transfer those interests to your living trust so you can bypass probate and avoid the types of problems that can come whenever there's an estate dispute. Again, guys, 6 points here that I wanted to get across when it comes to drafting an operating agreement. It's essential that you have that you set up an LLC operating agreement for your limited liability company, because there are many different ways in which LLCs and members can get themselves into trouble. Companies can be pierced. No asset protection. What you thought was going to protect you in the event of a lawsuit doesn't happen. And then you're left scratching your head going, where did I go wrong? Many times it starts with the operating agreement, but that's not going to happen to you because now you know the importance of setting up an LLC operating agreement. Hey, I can't stress enough how important an operating agreement is to your limited liability company. If you've already set up an LLC and you don't yet have an operating agreement and you want to explore this more, or maybe you've set up an LLC operating agreement with something like Zoom, and you're sitting back here going, wow, I don't know if this operating agreement has the provisions Clint was talking about in his video. If you want to learn how to fix that, click on the show notes below. You'll see there's a strategy session link. It's completely free. Click on that link. You get scheduled with one of the representatives from Anderson. We'll talk about your situation, discuss what you should be doing today, what you should be doing tomorrow with your investing, with your business, also how to reduce your taxes, and generally help you formulate a plan to move forwards and find success with whatever you're doing with your investing or with your business. Take care.